Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about Illinois probate claims. A probate claim is something that you file when someone passes away and they owe you money or they have some sort of liability to you. So it's a way to let the probate court and the executor of the estate know that you're owed money from the estate. So we're going to talk about when the deadline to file a probate claim is, how to file a probate claim, the process for disputed probate cases in Illinois, and finally the priority of claims in probate court. So let's talk about deadlines first, because that's the most important thing. The general rule is that the statute of limitations for probate claims is 2 years. But this is often shortened by notice that the executor can give. So the executor, who's the person in charge of administrating the estate, the executor can mail, and usually does, can mail notice to all known creditors and publish notice in a newspaper for unknown creditors. And that shortens the deadline to file claims. That's why the executor does this. So any creditors who receive the mailed notice from the executor have 3 months from the date of the notice to file a claim, otherwise their claim is going to be barred. Any unknown creditors who don't receive that notice have 6 months from the date of publication to file a claim. So if the executor does those two things, it's basically he shortens the deadline from 2 years to 3 months for known creditors that receive the mailed notice, and then 6 months to unknown creditors based on the newspaper publication. If there's some sort of error in the executor's notices, because these notices have to follow strict statutory guidelines, if there's an error, then you default back to the 2-year deadline to file claims. So let's talk about how to file a claim in Illinois. There's 2 different ways to file a probate claim. Probate claims can be filed with the court or with the executor, or both. So because the court charges a fee to file the claim, most people will file the claim with the executor, and then only if the executor disallows the claim, then file it with the court. So let's talk about how that works. So it doesn't take much to file a claim with the executor. You just have to send notice, basically, to the executor, detailing the name, the type, the amount of the claim. There's no formal claim requirements. You just have to give the executor notice, usually in writing, of the type and the amount of claim and who you are. The executor within 30 days should either allow or disallow that claim once he or she receives that notice. Disallowing the claim means that you intend to dispute it. The executor doesn't actually think that your claim is valid, that you're owed that money from the estate. Allowing the claim doesn't promise that the claim is going to be paid. It's accepting the claim and promising to pay the claim to the extent that funds are available to the estate. So as we're going to talk about later, the executors have to pay off claims in order of priority, and if the estate doesn't have enough money to pay off all its claims, allowing the claim doesn't necessarily guarantee that everything's going to be paid. It's just saying we're going to line you up with the other creditors, and to the extent there's money, we're going to pay your claim. So if you're a creditor and you've filed the claim with the executor and the executor gives you notice that he or she is allowing the claim, then basically your job is done. You just monitor the probate case and make sure that you get paid out of the assets as the executor promised to do. If the executor disallows the claim, gives you notice within 30 days that he or she is disputing the claim, then the next step is to file the claim with the court. And again, there's some courts, depending on the county, have claim forms you can fill out, and you should attach any documentary evidence like invoices to the claim form. But the basic information that needs to be included is, again, the nature, the type, and the amount of the claim, and who you are as the creditor. So it's basically enough to give everybody notice of what the claim is all about. So you file the claim with the court, and then within 30 days, a hearing is going to be scheduled. And it's not often that the full claim is adjudicated at that hearing, but at the hearing, what will happen is one of 3 things. One is either the executor can orally allow the claim, or the executor can ask for a continuance and basically say, I need to investigate this, and they kick the claim hearing down the road and reschedule the hearing. Or the third thing is the executor can disallow the claim and a trial will be scheduled. So trials in probate court proceed just like a trial in civil litigation. All the rules of civil litigation apply. So there may be discovery, written and oral. There may be motion practice. So if you want to learn more about how civil litigation works, we have tons of articles at learn-about-law.com. So you can read about the discovery process, the pretrial motion process, but it'll proceed just like a normal civil litigation trial. And at the end of the process, you'll have a hearing before the court where you'll have to, if you're making the claim, you'll have to prove that the claim is valid, and the preponderance of the evidence, more likely than not, is the standard by which the court judges who has met their burden of proof. So let's finish up and talk about priority of claims. In probate, if the estate has enough money to pay all of the claims, then everybody gets paid in full. If the estate is insolvent, meaning that there's not enough money to go around for all of the claims that people are making, then they get paid in full in order of priority. So there's 7 different levels of priority, and the first level has to be paid in full before you move on to the second level. If there's enough money to pay level 1 and some but not all of level 2, then the claims in level 2 will get paid pro rata, meaning based on they'll each get paid the same percentage of their claim, depending on how much money there is to go around. So we clear out each level one at a time, and if there's not enough money to pay all of a certain level, then everyone at that level gets paid the same percentage. So let's wrap up by listing the different levels of priority. The first is funeral and burial expenses, administrative expenses dealing with the probate estate, such as attorney's fees or the executor's fees, court costs, and statutory custodial claims. We've got an article on our website that talks about statutory custodial claims, so we won't get into that too much now. The second level is the surviving spouses or child's award. This is an award that is basically, it serves the purpose of maintaining the spouse and the children for 9 months after death. And there's a minimum award of $20,000 for the spouse and $10,000 for each child. So this is, if nothing is left to them through the estate, they're at least going to get the surviving spouses and child's award as long as there's enough money to get to the second level of claims. The third is any money owed to the federal government. The fourth is money owed to the deceased person's employees for services rendered within 4 months prior to death, and this is limited to $800 per claimant. Number 5 is property held in trust that the decedent, the person who passed away, commingled with his or her own money. So if there was property that the decedent was a trustee for, and he or she either mixed it with his or her own money, or basically converted it to his or her own use, so stole money from a trust, any claims like that are going to get paid out in the 5th level. The 6th level is money owed to a state and municipal government, and the 7th level, all of the other claims that can be made, so regular or old creditor claims get lumped into that level. So that's how probate claims work. We talked about the deadlines. We talked about how to file a claim. We talked about how disputed claims work and the levels of priority. So thank you so much for listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.